Yes, it's a Tuesday and it's that time of the morning when all your legal questions will be answered by the very wonderful David Whiting, who's joined me in the studio. Good morning.
Thank you, Allan.
1300 222 774 is the number. I really don't need to do this, but I will anyway. Or you can text on 0437 774 774. But calling is preferable in order to allow clarification. Now, you've been very busy, David, haven't you? I don't know whether you
I've had
homework,
4 days off, like everybody did. No, I have no homework from last week.
Can I just tell you that not everybody had 4 days off, just so that you know that.
Oh,
you know.
really?
Yes,
Are there people out there who work through the
Yes,
weekend?
I know, gosh, shock horror.
Yes.
But you did come in with a list of things that we can talk about prior to taking calls, and I'm interested in Brian Burke has died, and not the Brian Burke of
Western Australian
fame.
Brian was a barrister in Melbourne who died, I think it was Friday, and at the age of 88. Just an extraordinary man who wrote a textbook on liquor law and a textbook on criminal law. And he was, I don't know when he stopped working, but it wasn't that long ago. He was interviewed by Jon last year because he was one of the barristers who represented Ronald Ryan, who was the last man hanged in Victoria. So that's 50 years ago. And he was still working until recently. He was appearing in the Magistrates Court. He stopped doing trials. They involved a bit more work. But just an extraordinary gentleman. His dad had been a publican, tenure. But he was.
So his dad was a publican, and he wrote a book on the liquor rules.
Yes, but he never drank. So, but he did like a punt, and so just a very interesting man.
I wonder if the not drinking came from having a father in the business and watching what went on.
It could be, could be. Yeah, he was just always in control, was Brian.
Now, changes to suppression laws.
Yes, we have. In 2013, the government introduced the Open Courts Act. And what we found was with the introduction of the Open Courts Act, there were more and more suppression orders made. Now, it used to be that South Australia was the leader in the field, and you could get a suppression order fairly easily in South Australia. And with the Open Courts Act, it actually became easier rather than less easy to get one here. So there's been Frank Vincent, a former Supreme Court judge, has undertaken an inquiry and a review of the effectiveness of the Open Courts Act, made us a series of recommendations, and one is that we just have too many suppression orders. So one of the things that amazes me is one of his suggestions is that there would be a publicly accessible register of suppression orders, which seems to me to defeat the purpose of suppression orders, but never mind.
Yeah, how do you register it without giving it away?
Well, you know, the suppression order in relation to a case between A and B. But what's important, I think, is that suppression orders should ultimately expire. You know, at one stage.
Do they not now?
Well, sometimes you have. Well, it depends on how the order's made. It might be that the order is made without an expiry date, but sometimes a suppression order will be made because there are a series of trials involving co-accused and they're heard separately, and what you don't want is the jury to read in the newspaper of a result in a case that's basically identical to the one that they're dealing with, other than the fact that the defendant's a different person. So there's a place for them, but I was fascinated with the very concept of having a register so you could go and look and see what all the suppression orders were. Yes,
it does. The mind boggles a little as to how that might work. And finally, jail for underpaying super. This has got to be a good thing, surely.
Well, don't know. There's a proposal that's to be introduced into Federal Parliament tomorrow, which will allow the tax office to ask for jail time for company directors and employers who don't pay their staff super.
And this is obviously only when a company has collapsed, or at any point during the course?
When they're due, you haven't paid them. And
right.
You can be on monthly payments or quarterly payments, but you've got to pay your employees superannuation. And to date, the only sanction is there can be a fine of up to 2 times the amount not paid. The proposal is we're going to expand the list of penalties to allow for some jail time, but we haven't done it for wages. So it's kind of strange.
So what's the heaviest penalty for non-payment of wages?
Well, you can be fined. I don't know what the fine is, but it's not jail time.
It does seem a little strange, doesn't it?
Yeah, so we can have jail time for 10% of the package, but we can't have jail time for the other 90.
Surely should just
be
an obligation. I don't really like the idea
for jail time anyway, but...
Well, why not? If nothing else works.
Well, perhaps you might seize directors' assets. I don't know.
But it might focus the minds of a few directors, mightn't it?
It certainly will.
1300 222 774 is the number if you would like to talk to David Whiting. And Simon in Rowville, good morning.
Yes, good morning, David and Ellie. Just a query about life tenancies.
Yes.
My grandson was granted one by his deceased mother, but the terms of the tenancy were never actually explained to him as far as we can work out, and he's intellectually disabled, and so he never realised what was going on and never got a chance to challenge the will, and I'm just wondering how important it is that these things be explained before the tenancy actually can be said to exist.
Does he have an administrator or a guardian?
No.
So his level of disability is not considered such that he needs someone to take charge of his affairs?
Well, it hasn't been, but that's because people in South Australia where he resides are really loath to get involved with the people who do these things. Folk, funnily enough, don't trust the government and want to look after their own children.
Yes.
Unfortunately, in this instance, his father, who remained in charge of him, was himself borderline intellectually disabled, certainly never had any grip on the terms of the will, and it wasn't until I came on the scene a year or so later.
Simon, can I ask you a question?
Yep.
Apart from the fact that he doesn't own the house, but he's got the right to live there till he dies, was he otherwise appropriately provided for?
Nope, not a penny. His grandfather promised to pay a whole lot of money to maintain and repair the house, but never actually did so.
So what kind of... I mean, it might be possible to bring a claim against the estate out of time?
Well, we were actually hoping to bring a claim against the public trustee who were administering the will because they never explained it to Chris.
I don't, in all honesty. I mean, the public trustee, state trustees, whoever the executor is, has an obligation to uphold the terms of the will.
Yes, I understand that, but they never actually explained the will to the only person to whom it matters. And any sane person would have challenged the will right at the word go. Because there's no reason for the life tenancy.
But hang on a minute.
The person who benefits from the life tenancy is his aunt, who is independently wealthy, owns her own home and has no need of the
Simon,
will.
It's not the public trustee's obligation to say to a beneficiary, we think you've been poorly done by here, you should make a claim.
But they do have to explain it to him, and given that they wouldn't have been capable of doing that, they would have had to appoint an administrator who would have had a grip on the subject.
Simon, why do they have to explain it to him?
Well, so that he understands why he's paying all this money he's paying. He's been supporting mortgages against the will, which itself seems a little bit odd. He's been paying all the outgoings, the rates and the taxes and what have you, and they keep making more demands on him. But he has no idea of what's going on.
So his mother left him a life interest in a property with a mortgage on it?
Yes.
So in the normal course, what would happen is the property would be sold?
Yes, but he had the wherewithal with his mother, well, his stepmother and father and himself with their pension and what have you. He was easily able to account for that.
Then he may consider making a claim against the estate out of time because the estate's not fully administered.
Right, but the problem is the estate has no assets other than the house.
Yes, but can you see that's the very issue?
Well,
I mean, the answer would be he could make a claim for the house.
Yeah, but the problem is now it's worth nothing. I mean, what he wanted to do, what he should have done...
I'm sorry, Simon, why is it worth nothing?
Well, it's only worth something in the sense that if he took the legal action, and this is part of the problem, we can't get anyone to help.
And the other problem is that, well, yeah,
he'll end up with nothing, no matter what happens.
Because everybody's costs will be paid out of it.
Yes, exactly.
So in effect, he may well have got the maximum possible benefit out of the estate anyway.
Well, no, because if he'd owned it outright, he would have been able to take out a mortgage.
He couldn't have owned it outright because the mortgage would need to have been discharged.
Yeah, but
he would needed to have paid the costs of the public trustee in administering the estate.
Yeah, but all that's fine. But the real problem is that...
my problem, Simon, is that you're trying to impose an obligation on the public trustee that I don't think the public trustee has.
Don't they have an obligation as the public trustee, not as a commercial lawyer? I mean, it took me about 3 years to work out that they weren't acting in Chris's interest, but were simply acting as a commercial lawyer.
No, they were acting I don't know what the legislation is in South Australia, but they were acting in their role to give effect to Simon's mother's or Chris's mother's will.
But don't they have an obligation, doesn't the state have an obligation to look after the interests of disabled people?
The public trustee, you will find, whether it be an individual or a corporation, has a separate legal identity to that of the state. So I can't. I mean, it may well be that had it happened at the time, he could have made a claim for the estate. His aunt could have stepped aside. There were all sorts of things that could have happened, but they haven't. I mean, what I would be doing at the very least would be seeing whether I could change the mortgage from a principal and interest mortgage into an interest-only mortgage, because there's no reason why he should be saving money for the benefit of his aunt. Thank you, Simon.
Thank you, Simon. Rick in Doncaster. Hi, Rick.
Yes, hi, Ali and David, and thank you. This relates to my mother, an 85-year-old lady who has had her licence for over 40 years. Late last year, my dad, her husband, had a stroke, and she was driving to the rehab centre.
With him in the car or to see him there?
No, just to see him there.
Yep, all right.
She went through a red light, and there was a camera. It was a turn that she was doing. And anyway, it was her first driving offence of any sort. Never copped a parking ticket or anything else.
Yep.
And she wrote to the
traffic camera office and said, "Can I have a waiver?"
That's right. And they said, "No, you cannot."
Yes.
And we're wondering, is there any subsequent recourse?
But if this is her first offence, then it's not going to be an issue, is it, for her licence at all? She hasn't lost so many points that she's off the road.
No, that's right. The only thing is that her husband was the main the only breadwinner, and the income has dwindled.
And the fine is hefty. Yep.
Rick, the difficulty is that the starting proposition is you pay the fine, and what you then do is you have the right to apply for a waiver.
So you pay the fine and then you apply for the waiver?
No. Oh. Your starting proposition is if you get a traffic camera offence, a notice, then that's an infringement notice that you in prima facie pay on. Now, the 85-year-old has said, yes, I have committed the offence, but because of my good driving record, I want you to waive it. Yes. That, in a sense, is already the appeal.
Right.
So there is no further appeal from an appeal. Right? Because the starting point is, look, we think you went through a red light camera, what do you have to say? That's not the starting point. The starting point is, here's an infringement notice, and from there you go to, you are now nailed. So I'm sorry, no, the answer is that's the way.
However,
you could go to court.
Could Rick's mum, though, perhaps get a payment plan rather than have to pay it in one hit?
I'm not sure. How much is the fine, Rick?
400 and...
Look, it might be possible, but they might say it's too small for an instalment plan. Okay. But you might try a plan.
Okay.
Rick, good luck with that. Allan in Berwick. Hi, Allan.
Hi. What I'd like to raise is the Nicholas Gruen on international TV just basically said that banks are creating 97% of the money that they lend basically doesn't exist. And it only becomes money when it becomes debt. It seems to me this is a fraud of the highest order. I know it's gone on basically since they got rid of the gold standard.
Allan, the concept that you're talking about, which is the multiplier effect, has existed since we've had banks.
Well,
right? So if you start with $100, you go and put it in the bank. Well, I'm the bank. I can now lend it out to someone who will then go and buy something, and the person he buys it from will put it back in the bank. So in theory, I've now got $160 in the bank.
No, that's not correct. Basically, fractional reserve lending, they can take your $100 and lend it out 1,000 times. And internationally, basically, banks are quantitative easing like no tomorrow, creating money like no tomorrow, and governments are borrowing off them. And that's just printing money. I'm sorry. The truth is, banks are able to print money, basically, and Nicholas Gruen said it, Bill Mitchell said it, heaps of economists have said it, that they're creating money from nothing and lending it.
And is that what you want something done about?
Well, I believe there should be a class action, because if the money doesn't really exist and only becomes money when it becomes debt, if somebody defaults, they seize the asset.
Yes.
Win, win, win. You know, this
I'm
is
sorry.
incredible.
America has a system of foreclosures, right, where the asset normally goes to the mortgagee. The rules in Australia here are that the asset is sold and the proceeds used to reduce the debt. So the bank, in 99 times out of 100, does not end up with the property.
Well, they end up with the value, basically.
Yeah, but it's the value they lent.
Yes, it's just a return of what they've put out.
Yeah, a return of nothing.
Well, everybody perceives it has value other than you, Allan, because the person who received it when the mortgage advance was made thought he or she got value. The person who borrowed the money to give to the person who owned the property before believed they got value, and they're now being asked to give the value back. I don't see... I'm aware of the way it works, because we assume that there are going to be certain bank balances all the time. But if I take it out and pay it to you, Ali, you're going to put it in the bank, and therefore the bank can have notionally lend it again.
If you're lucky. I might just go and spend it. Allan, thank you. Look, good luck with pursuing that. Richard in Ballarat. Now, you're actually following up a conversation that you had a couple of weeks ago with David.
Yes, thank you. Good morning, David and Ali.
Good morning.
I had a query regarding to the slow processing in fines Victoria, which you kindly investigated, David.
Yes.
Subsequent to that, I did get a reply from the Sheriff's Office, and the response into the warrant for seizure of goods, they had a whole pro forma which they ticked the box. The judgment debtor has left the warranted address and no further information is available. My question is there any more that can be done?
Not unless you can find the person who owes you the money.
Okay.
Now, how much is the debt, Richard?
Oh, it's about $500-something.
Right, so it's not enough to bankrupt them. You need, I think it's about $2,500 to bank. Unless you can find them? No.
Yeah, so it's more the principle, I think, because they're basically scamming not only me but a whole heap of other people.
Do you know if they own a motor vehicle? Is it a tradesperson?
No, I don't. Sorry, I don't know their personal. What
then
they
the sheriff can only attack. The sheriff's not going to go and look for the person. You have to tell the sheriff where to seize.
You've got to find them first.
I understand the warrant. Is it still live for 12 months, or is it now?
No, well, you can ask them to return it, but don't do that. Put some effort into finding them, and then you pay what's called a redirection fee.
Oh, okay. All right. Well, thank you very much for your advice.
Thanks, Richard.
Richard, good luck. A couple of text messages here just regarding that fine, that red light fine for the elderly mother. Jane says that she got a payment plan on a fine of less than $400. And Gail says an instalment plan will definitely be accepted for the elderly lady with the traffic light offence. So there you go. Certainly worth trying it. Sue in Heidelberg. Hi, Sue.
Oh, hi, David. Hi, Ali. I'm ringing about the sale of my late mother's home. We want to avoid paying capital gains tax.
Yes.
And so I just want to check my understanding. Do we need to sell it within 2 years of her date of death? And is it the contract signed or is it settlement?
It's the date you sign the contract. So if you sign the contract of sale within 2 years of your mum's death, then there will be no capital gains tax, assuming that it would have been capital gains tax free if sold by your mother during her lifetime. Because, I'm assuming that all the time she owned it, she lived there?
Yes, yes.
Okay, then there would be no capital gains tax if sold within the 2 year period. But there might be advantages in keeping it and having a valuation as at the date of death. What happens if let's say you take 3 years to sell it, then you're going to need to get an assessment of its value on the day your mum died and use that to calculate your capital gain.
Okay, so she died a year and a half ago.
Yes.
So can you get a valuation?
A valuer will be able to say, this particular house in this particular month was worth, in my opinion, this amount of money. But you want a single figure, not a range. And that you could use that as the basis for your calculation. Now, it may be that you want to do something to it to make it worth a little bit more, but remember you're only paying capital gains tax on the upside. So if we assume that the house was worth $1 million when your mum died, and it's now worth, or if you wait 3 years it becomes worth 1.1, your capital gain is 100,000, your taxable capital gain is half that, and your tax is no more than half that again. Right. So there may
be an argument to keep it.
There may be an argument to keep it, but
depending on your reading of the property market.
Yes, yeah, and rezonings and all sorts of things.
Mm-hmm. So good luck with
Great.
that.
Thank you very much. Thanks. Cheers. Bye.
Peter in Doncaster. Oh, sorry about that. Peter, hello. Oh, I don't know. We're not actually calling Peter. We seem to have... Yep, I shall just get rid of that. Don't look at me like that, David. It's all right. Peter in Doncaster. Good morning, Peter.
Hello, David. Look, I'm interested in the body corporate documentation that relates to 4 units I bought. They were strata-titled units I bought many years ago.
Yes.
And on settlement, all I got was the body corporate stamp.
Yes.
Now, they were built in about 1975.
Mm-hmm.
And I'm looking at selling them, and I'm wanting to sort out what I need to do about the body corporate, and are there common documents to all properties back in 1975 that relate to the body corporate issues?
In 1975, it will have been the Strata Titles Act 1967 that applied to your development. And there were a series of standard model, what I call model rules. What I don't know is whether the model rules have been, and it may be that they're the model rules that apply to you, and it may be they may have been updated by legislation. So if you can wait next week, I'll tell you whether the Owners Corporation rules under the Strata Titles Act have been updated by the Owners Corporation Act or anything in the middle. Is that what you're after? So there'll be a set of model rules.
I suppose my other question is, the bank still holds the deeds. Would body corporate literature be attached to them? I know they wouldn't be attached at the titles office.
there is no... You own all 4 units and there is some common property, is there?
Yes.
All right, then you simply insure everything.
Yes.
Yep, and you're going to sell them separately or altogether?
Probably separately.
Then you will need to... you'll need to make a series of resolutions in relation to the Owners Corporation, and you'll need to take out some insurance in the name of the Owners Corporation for the common property.
Right.
Peter, thank you. Val, good morning, Val.
Oh, hi, Ali. Hello, David. Thanks very much for taking my call. I'd like to know my legal position. I'm being stalked by an adult male, and I know that's rather a contentious issue at the moment, but I'm an age pensioner, and I have human rights too. I'm being stalked on a nightly basis for over 2.5 years. He has a knife, and there's also property damage. I live in fear of my life, and the police are doing nothing. I've been discriminated against.
Why are the police doing nothing, Val?
I don't know. I think there is discrimination. I'm an age pensioner. I'm female. I live in country Victoria.
And which of those elements is the discriminating factor?
Well, also, I'm not local, and there's a familiarity here with the police and the carer of this disabled male. I have tried for a safety intervention order. It was contested, but the carer mother committed perjury in court, and I was unable to follow up the next court date because I was confined to bed. It's had an absolutely horrific effect on my health. And so
you've had a preliminary hearing,
yes,
and you didn't turn up to the second one because
I was unable to.
Yes,
and another police officer that I've dealt with, he said, "Don't put yourself through that." I mean, the woman lied in court, and I can't fight lies.
Val, we have to be very careful here about obviously identifying. But David, do you have any advice for Val? Is there anywhere else that she can go?
Well, I think your legal advice is that you can either... Will the police commence a proceeding for you?
No.
And why do they say no?
Well...
Do they say there's not a realistic risk?
I have tried everything. I've reminded...
No, sorry.
Sorry, David.
Why do they not pursue the matter for you?
I do not know.
Have you asked them that question?
I have.
And
I have
their
put
answer
everything
is?
in writing.
And their answer is?
Well, no. Their answer is no.
Now, the answer is that's not an answer to why.
No, I think that you need to pursue it with them about why they won't, so you actually can get an understanding of what they're doing. But I think that we're getting into slightly difficult territory there, David.
So the issue, though, is that, she's got the ability to bring her own action, but I suppose, and I would have thought you would normally apply for an adjournment on the basis of ill health, but maybe Val didn't bring the matter to the attention of the court, and so the matter proceeded on the basis that she didn't pursue a case. I can understand the difficulty in a small community where everybody knows everybody else but you. I would be going up the higher levels of command of police.
Well, there you are. That's David's advice. We're just going to squeeze in one more quick call from Simon in Caulfield. Hi, Simon.
Hello, Ali. Hi, David. Thanks for taking my call. David, my partner's father passed away about 9 years ago.
Yes.
Unfortunately, we only found out about this about 4 or 5 months ago.
Yes.
The will is directed to her as far as she was the sole beneficiary of his possessions. And we are curious, I suppose.
So Simon, what you're saying is that your partner received the personal property of the person who died, is that right?
Was supposed to receive the property of her father.
Under the terms of the will, she got his clothing, jewellery, personal effects, that kind of stuff.
That's right. That's what was nominated, yes.
Yes.
She wasn't told of his death, and therefore whatever possessions he has had or had at the time haven't been distributed to her, and we are of the belief we know whom might have them.
Yep.
But we're wondering what grounds we have, given that it's 9 years on.
Your action is against the trustee. Your action is against the trustee for breach of trust.
Breach of trust.
Yes.
Okay. Right.
And sorry, can I ask? Did you not know what the terms of the will said, or did you not know that your partner's father had died?
We didn't know he had passed away. That's right. Yeah.
Okay.
Yeah.
Did the executor know where your partner was?
We've been told that they tried to reach out to us, or to my partner, and she has had the same phone number for, the many years. And that phone number, I think, is on the will document, yet no one did contact her regarding.
Well, I'd probably also talk... Was a grant of probate made of the man's will?
What does that mean, David?
Well, did somebody did he have property that needed a formal executor and an application to the Supreme Court to administer the estate?
No.
Okay, so it was a small estate, right?
Yes, that's right.
Your action is still against the trustee, and that's about it.
Simon, good luck. That seems like a fairly clear-cut direction that you have to head in. David, thank you. Lovely to see you again. David Whiting there from Whiting Lawyers. And